Greetings and welcome to another installment brought to you by Mohamed Marzooqi, advocates and consultancy, leading legal experts. Wreckage selling precautions for insurance companies. The United Arab Emirates has passed laws to combat commercial fraud, such as the Fraud Prevention Act in the Commercial Transactions and the Consumer Protection Act, as well as other provisions contained in other laws, i.e. corporate law and intellectual property laws. The Federal Law number 19 of 2016 was issued with the aim of combating commercial fraud. The provisions of this law apply to anyone who commits commercial fraud, and the free zones are not excluded from the application of these provisions. And the federal law defined commercial fraud as any of the following acts: import, export, re-export, manufacture, sale, display, or possession with a viewing to sell, storing, leasing, marketing, or handling counterfeit, corrupt, or counterfeit goods. The new law has increased the penalty so as to be a deterrent. Article 12 of this law states, an individual shall be punished by imprisonment for a period not exceeding 2 years and a fine of not less than 50,000 dirhams and not more than 250,000 dirhams, or one of these penalties, whoever has committed the crime of commercial fraud. The new law comes in response to the need of the consumer. It protects them from fraud, where commercial fraud inflicts heavy losses on people, such as when they buy counterfeit goods. This law also constitutes a primary defence for the protection of companies operating legally, as well as trademark owners. One of the areas where crime of commercial fraud can occur often is the sale of cars and their spare parts, which may sometimes be counterfeited. Article 16 of this law is the most important point for our subject and states, the merchant shall not be exempt from the penalty prescribed in this law, the buyer's knowledge that the item is fraudulent, corrupt, or counterfeit. We've recently read news stories about conviction of a vehicle seller because of a defect in the chassis. This led to the failure to pass the technical examination. The federal court sentenced the seller to 2 months imprisonment. This meant the vehicle was not registered with the traffic department and licenses, although the seller held that the buyer was aware of these defects and that the buyer reported in investigations that he knew of the existence of these defects. This story was published in the Emirates Today newspaper. We want to highlight here that the insurance companies are selling vehicles after being involved in traffic accidents, as the warehouses of insurance companies in large number of car wreckages resulting from traffic accidents, which are transferred to the insurance company after it compensates the insured. Therefore, attention should be drawn to Article 16, which states, the merchant shall not be exempt from the penalty prescribed in this law and the buyer's knowledge that the item is fraudulent, corrupt, or counterfeit. The insurance company must clearly indicate that it does not sell a vehicle but rather sells the wreckage of a vehicle. The buyer is aware that the wreckage was left behind by a traffic accident that made the vehicle unsuitable for driving, and the buyer knows all the details of the damage in the wreckage, and the sale was not based on the repair and the resale of the vehicle, and the insurance company is not responsible for ensuring the vehicle's success and passing the traffic check. The fact is that insurance companies can use the Emirates Insurance Association and the Insurance Authority to issue a mechanism to ensure they are not liable in such cases. It's important to note that insurance companies in many cases sell the wreckage to a particular person, mainly merchants, and the transfer of wreckage to someone else at the request of the original buyer of the wreckage is a very sensitive and dangerous, especially if we know that most often the buyer who is transferred to the insurance company wreckage is a final consumer and that the transfer is after the repair of the vehicle. This situation is common in the insurance companies, but there are serious caveats where the agreement is often concluded between the insurance company and the first buyer, and the last buyer is not a party to the agreement and does not invoke it to expose the insurance companies to liability in accordance with Article 16, which we mentioned earlier. At the present, to ensure the safety of the vehicle or not, it's the one who sold the vehicle to its final buyer who is responsible in the face of it, or at least responsible in conjunction with the dealer of the wreckage. And these are all precautions which should be taken care of and from any problems that might result from them. Not only that, but the transfer of the wreckage to someone other than the person who has paid the price is not proper, as if the dealer has to write off the vehicle in the name of another person. The request must be written and may not be given orally to avoid the problem of the first buyer's objection. In summary, the insurance company must be careful and determine the formulation of the sale contract between it and the purchaser of the wreckage, and to deal directly and predict fundamental agreements that ensure the safety of its possession and put a mechanism on which the company to deal with the situation of the sale of wreckage, whether it's the insurance of the vehicle or the other insurance which can be left behind the items or goods damaged sold by the insurance company after the compensation of the insured. This message is brought to you by Mohamed Marzooqi, advocates and consultancy. We do have offices in Dubai and Abu Dhabi. Please contact us for your consultation. Alternatively, you can visit our website, which is www.ml-advocates.com.